I did say yesterday we'd look at that aspect of the story, which is the raging debate on whether a juvenile should be treated with great compassion, or in this particular case of Nirbhaya, whether the law is being too lenient on the juvenile who was also the worst perpetrator of the crime, the most monstrous member of this group which carried out this attack on the Delhi gang rape victim. This debate continues. And tonight on the panel, we have 7 points of view. Soli Sorabji joins the panel, very esteemed former Attorney General of India, former Chief Justice of the Punjab and Haryana High Court, Justice Mukul Mudgal is also on the panel this evening. We have Purnima Advani on one point of view, who is the former chairperson of the NCW. We have Ranjana Kumari with the other point of view, director of the Centre for Social Research. Malavika Rajkotia, who was with us yesterday, is back. Subhashini Ali is president of the All India Democratic Women's Association. And Kavita Srivastav is national secretary of the PUCL. Thank you very much, ladies and gentlemen. I am very glad that we are looking at this debate once again. Purnima Advani, this cannot be a closed chapter, can it? That the law cannot be changed. This is the law cannot be changed.
The law
Yes.
Look, the law can be changed, and in fact the law should be changed from time to time to keep pace with social dynamics. Law can, in fact, the reverse is true, that law can never and should not be stagnant and static.
So in this case,
having said that, every case has to be decided. In this case, it will have to be decided by the law of the land, as it is on the date when the incidents happen. Very unfortunate, but that's the law we are governed with. And this is just a reflection of complete lethargy and a lackadaisical attitude of the parliamentarians in not contemplating what should be the changes in law. It's only a knee-jerk reaction. When an event occurs, then the promises are there. Nirbhaya's case is extremely unfortunate, and in this case there is no reason why the juvenile should not have. We should have had a law to deal with the situation. And even today I would say that there must be an exception made. My personal view is in the age group of 16 to 18, where in serious offences serious action should be taken, stringent action should be taken, so that there is a deterrent impact. We cannot just put our hands up and say that this is what has happened.
Precisely.
But unfortunate, again I underline, extremely unfortunate in Nirbhaya's case, we are being governed by the law of the land as it stands on the date of the incident.
No, I'm not sure.
And therefore we are bound with what the Juvenile Justice Act says as of today.
I'm not sure, because in this case, Kavita Srivastav, let's get the other view. Because in this case, you know, they went by a school certificate. Now, I have a Supreme Court case, which I can then bounce off Soli Sorabji later, but I'd like to get Kavita Srivastav first, which says, this is a Jyoti Prakash Rai versus State of Bihar 2008 case, which says accused claimed he was a juvenile. He produced a school certificate and a horoscope, same were found to be forged and fabricated. It was held in such a case, the court has no other option but to determine the age on the basis of medical reports, even though they are not conclusive. There is another case which says, Kavita Srivastav, 1 minute. The Honorable Supreme Court observed this Pappu versus Sonu 2009, since the doctor had failed to indicate the basis on which his observation with regard to the radiological age of the accused is 18 years, the same could not be relied upon to discredit the mother's evidence on the school record. In other words, in this case, you have to carry out a bone ossification test. This school record is not good enough.
See, I mean, that could be your opinion that the school record is not good enough. My point
Supreme
is
Court opinion.
Whether the person is
Supreme
17 and a half or 18. See, yeah, I mean, Supreme Court's opinion. And see, my point is, give reform a chance. We cannot be devoid of a society that does not allow its young people, children to re-enter. Even at the outset, we are trying to condemn. Yes, he committed a heinous crime, but what the present law says, I think, is very good, that he can be put under 3 years of rigorous, observation. I think we can reform him. We can reform hardened criminals. Kiran Bedi did it. She did it in Tihar jail. So I really think, why this big hue and cry that we are making? No judge will put even an 18-year-old to a life imprisonment, because the person will be out at 30. So listen, I mean, I really think we need to work with reformatory homes. We need to invest. We need to really do something about our homes. We cannot brutalize our children
reform,
anymore.
but according-
the system is
What
a
about repeat offenders?
co-perpetrator of that crime.
What about repeat offenders?
The system is a
I'll get-
co-perpetrator. The system has to take responsibility.
Sure,
I think we should pitch for reform.
According to the Juvenile Justice Board, the Delhi police and the authorities at Tihar, Kavita Srivastava, 15% of juveniles accused of serious crimes go on to become repeat offenders. Out of these, several repeat
Because we are not
serious
working with
sexual
them.
offences. No,
Because
this is.
we are not working. We are not treating them as human beings.
I am talking about. I am talking about those who've been through the reform process, Kavita Srivastava, not those who haven't.
No, there's no psychologist. There are no counselors. Please, this boy, no assessment has been done.
This.
I mean, a child grows up without parents.
I get a third point of view.
What are we doing?
A third
This
point of view,
child
Ranjana
grew up
Kumari.
without parental
One minute.
guidance.
I'll get all points of view.
6-year-old child
1 minute,
had
Kavita.
to leave home
So,
and come and wash
Kavita-
dishes in dhabas.
Kavita Srivastava, as I said yesterday, some sympathy for the victims as well will perhaps be appropriate. I'd like to get in Ranjana Kumari at this stage. One minute, Kavita. Let's get the other
Full
view.
sympathy
Let's get
for
all
the
points of view.
victim. We want justice.
Yeah, sure.
But we cannot
Sure.
deny the rights of the accused. We want justice.
The number
in
of
Nirbaya's case. But we cannot deny the rights.
according to the latest data,
They are also human beings.
the number
Treat them
of
as
the
human
number
beings.
of juveniles held on charges of rape were more than the number of juveniles accused of murder. I want to get in Ranjana Kumari at this stage. Ranjana Kumari, give reform a chance. We heard this before. I want to take the debate forward. Your response to Kavita Srivastava.
Arnav, first of all, it is a very serious debate and I want some ground rule. Ground rule is that let me complete, let everybody else say everything. There is no point in screaming, shouting or trying to be very emotional about the whole thing. Let's be very rational. First of all, this whole situation in which this particular crime is not crime of innocence. This is a crime which we have to look at the nature of crime. This person who has already crossed 17 and a half years, and in mathematical calculation, in any case, when you cross 0.5, then when you go to the other side, it is rounded off as 18. Anyway, this is all to be established. Nation needs to know, for the sake of justice, what is really the age of this person. Because school certificates can always be manipulated and can always be wrong. Coming from our own experience, I know that this is possible, that, So first of all, nation needs to know, and also, as you always say, that we want to be convinced about the age of this person, so that when justice is delivered, there is no doubt in nobody's mind about the age of this person.
You're not convinced.
Number one.
You're not convinced on a school certificate?
No, we are not convinced.
You're not. Why aren't you convinced?
No. Second thing.
Why aren't you convinced?
Listen to me.
No, tell me, why aren't you convinced?
Let me come to the second point. I am not convinced because A, that it can be manipulated. Time and again we have seen high school certificates being manipulated.
Precisely.
It is very easy to get wrong information given to the school. It is very easy because there is no birth certificate. There is no entry or registration of the birth. If there is no registration of the birth, you can just talk out of memory when you go to the school and register the age of the child. It is absolutely irrational system that we follow.
Yeah.
So that is why we need to ascertain the age by the bone test. Second thing, Arnav, let me just complete one more thing. Second thing, while we believe in child rights, while we believe in reform process, and we are all shouting, screaming, saying psychology and sociology of the criminal, there is a psychology and sociology of each and every criminal if you go into the detail of psychology and sociology. But look at the nature of crime, look at the way 18-year-old with full knowledge, 17 and a half let's say, with full knowledge, knowing what the person is doing is not act of innocence. The nature of crime needs to be considered. And let me tell you, votary of human rights and child rights globally have looked at these situations and have made exceptions.
I am
it is not that only we are the ones who can't change the law.
Now let's get everyone in, otherwise I won't be proportionate. Otherwise I won't be proportionate. So, 1 minute. No. Otherwise I won't be proportionate. I want to get everyone in. Let's get Soli Sorabji. I want to present a case study to you, sir. A 17-year-old boy and his friend 16 suffocate their grandmother. A 17-year-old boy suffocates his grandmother to death. This happens in May 2012 because the grandmother stops the 17-year-old boy from stealing money and jewelry worth 10 lakh rupees. The boys are sent to a remand home, Soli Sorabji, in 2012 in July. They are released in less than 2 months.
Yeah.
So,
Yeah.
what do you think about a case like that?
But the question is this, Arnab, I have a different take. I'm not enamored of 15 and 16 and 14. The Indian Penal Code, so over 12, he can be treated as any other accused. Point is, the test should be, was that person capable of knowing the nature of the act and its consequences?
Yep.
And did it do it with full knowledge of that?
Yeah.
Yes.
I don't see this number game. 15, 16, I think it's inherently arbitrary. There should be that. Because if you look at this, suppose hypothetically Kassab was 17, what would happen? You say he'd be reformed. We let him off. I mean, it's so self-evidently absurd. I understand the plea for reformation, but at the same time there are certain crimes which are really require retributive punishment. And also a message is a crime only also in society. So I don't like this number game. Make the test the mental position, capacity of the person who committed the crime. If he was aware of it, knew the full consequences of it, then there is no question of then saying, oh, he's juvenile because he falls short by 6 months. I find that inherently irrational.
Justice Mudgal, you agree with Soli Sorabji?
And the example which you gave, Arnab,
Yes.
the example which you gave would shock anyone's sense of justice.
Yes, Justice Mudgal.
No, I generally agree with Mr. Sorabji, but here I'll have to slightly differ. You see, as far as the age is concerned, it is defined in the Act.
Yep.
And your title of your debate is the seriousness of the crime determine the age of the juvenile. I don't agree with that. The answer has to be no. But if you see section 16 of the Act as it stands today, the impression today that he'll be released in 4 months is not correct. 3 years can be imposed, and it could be in a special home or any other place. It depends. If he is more than 16, there's a special proviso in section 16 which says that if the nature of the crime is so serious that the state government can create a special home for him or any other designated place. It could be even in Tihar, where he is not in association with adult criminals. So that is my take on the law. It stands. What the law should be,
One sec. Soli
as a matter of debate,
Sorabji had a minor rebut
and
to
the
you, sir.
legislature will look into it.
Soli Sorabji just wanted to counter
Yes,
you
please.
briefly. I'm coming back to you, Justice Mudgal. Yes, Soli Sorabji, what were you saying?
Please. Look, he's been my senior. I respect whatever he says.